Welcome to another episode of Sunday World Engage. My name is Mpho Koka. I'm coming to you live from the Constitutional Court in Braamfontein, Johannesburg. We are here for the much anticipated judgment in the matter between Vodacom and please call me inventor Nkosana Makate. Standing next to me is Mr. Mudise Sitwaba, convener of the Please Call Me movement. Ntate, now during the arguments of this case in November last year, Vodacom was actually arguing that the only offer or money they can give to Makate is 47 million. That's what they said. So they said that's the only amount that they can give him. But Makate is actually looking for around 9.4 billion.
Look, Vodacom has got apartheid babalas. You have to understand that the Constitutional Court, on its own, is not a civil litigation court. The SCA has pronounced itself, and it has given Makate 9.4 billion, I think, plus interest. So look, it's because Vodacom has delayed to do right by Makate, thinking that he's going to be a walkover like the rest of them. So now their delay and their lies has caught up with them. So the amount, whether is however billions, it's neither here nor there. Fact of the matter is the case is 24 years and they didn't honor the commercial contract. So it serves them right that they have to pay what they are paying now, or they're going to be told to pay.
All right, thank you, Mr. Stwaba.
This application is yet another instance of the unending litigation between Vodacom Pty Ltd, the applicant, and Mr. Nkosana Makate, the respondent, a former employee of Vodacom. The litigation, which spans just under 2 decades, concerns compensation owed by Vodacom to Mr. Makate for the Please Call Me PCM idea. Negotiations between Mr. Makate and Vodacom were unsuccessful and the matter was referred to the CEO. After a thoroughgoing process, the CEO determined that 47 million rand was reasonable compensation for Mr. Makate. Mr. Makate was entitled to 5% to 7.5% of the total revenue share of the PCM product, and that the total revenue of the PCM product should be calculated according to the computation models for compensation proposed by Mr. Makate. There were several seriously disputed issues in respect of which swaths of evidence were adduced and written and oral argument presented by both parties, all of which were disregarded or misunderstood by the Supreme Court of Appeal. But there are errors in the assessment process that are so fundamental as to go beyond this ordinary level of human fallibility. And those are errors that are so far-reaching as to result in a total failure of justice. The purpose of giving these few examples is to illustrate that the Supreme Court of Appeal, A, failed to provide adequate reasons for its judgment, B, disregarded or was unaware of certain material facts and issues before it, C, at times merely highlighted the parties' arguments in respect of central issues, but did not engage with those arguments in any meaningful way, D, failed to assess evidence that was abused by the evidence which it ought to have assessed, and E, readily accepted whatever Mr. Makate proffers without explaining why it did so. Based on these holdings, I conclude that the Supreme Court of Appeal failed to discharge the duty of proper consideration. This failure violates the rule of law and the fair hearing right protected in Section 4 of the Constitution. The judgment of this court penned by me is unanimous. In this judgment, we dealt with factual issues, but crucially, without deciding them, purely to demonstrate the Supreme Court of Appeal's failure to comply with the duty of proper consideration. The matter must be remitted to the Supreme Court of Appeal for a proper determination of the appeal, and that must be before a differently constituted panel of the Supreme Court of Appeal. The court makes the following order. 1. Leave to appeal is granted. 2. The appeal is upheld. 3. The order of the Supreme Court of Appeal is set aside. 4. The matter is remitted to the Supreme Court of Appeal to be reheard by a differently constituted panel of judges of that court. 5. Each party must pay their own wasted costs in respect of the abortive hearing of the matter in the Supreme Court of Appeal. 6. The first respondent must pay the applicant's costs in this court, including the costs of re-counsel. I hand down the judgment.
Today, how do you feel with the being referred back to the Supreme Court of Appeal?
No, obviously, we expected a different decision, and we have to abide with the court decision. And we're going back to the SCA because they have said that the SCA must apply themselves properly, and maybe outline the reasons that actually led them to a decision. That's what we're going to do. Yeah.
Do you feel that you've been let down by the legal system?
I think the CC could have probably finalized the matter. We still had a hearing at the High Court, which they could have gone to as well, and then ignored the SA completely. They are at large to do that, and they could have done that, yeah.
You've been described as resilient by many South Africans. You've kept on going thus far. Are you still feeling like a resilient man after this?
Well, I'm still resilient. I'll forever be. We'll go to the SCA, and the SCA must just relook at the case and then provide us with the judgment that will then stand the test.
Yeah, so you talk about the shortcomings of the ruling from the SCA.
Well, the court has not decided on anything that the SCA has done except for them not to express themselves on certain things that were before the SCA. So clearly, they just need to address themselves on those things.
But they're saying there are problems with the way in which you computed your...
Well, if you listen to what Justice Mbuyiseni was saying that in terms of especially the determination of the CEO, they did not, I guess, thoroughly deal with that and why it was inequitable. And I think the High Court did that. So, yeah.
Do you remain confident that you'll be able to convince the SCA that you are entitled to the over 9 billion rand that you've let?
No, definitely. It's our case. We'll also address the issue of the cross appeal, which they want us to do, and we'll do that, yeah.
Yeah, but the legal costs of fighting this battle continuously are enormous. The average litigant would not be able to do what you
Yeah, but I know, but we'll do what we have to do, yeah.
Okay.
Thank you so much, and all the best.
Are we fine?
Yes, sir.
Thank you.
We are back here at the Constitutional Court in Braamfontein, Johannesburg, where the highest court in the land, the Constitutional Court, handed down its judgment in the matter between Vodacom and please call me inventor Nkosana Makate. So in its judgment, the Constitutional Court ruled in favor of Vodacom and upheld Vodacom's appeal against the February 2024 decision by the Supreme Court of Appeal to set aside Vodacom's offer of 47 million to Makate. The Constitutional Court also ruled that the matter now between Vodacom and Makate should be sent back to the Supreme Court of Appeal, the SCA, so that the matter can be heard again in front of a new panel of judges to decide whether the 47 million offer by Vodacom to Makate is fair and equitable. Now, after the judgment was delivered, in his reaction, Makate and his legal team said that they will challenge the decision of the Concord and they will go back to the Supreme Court of Appeal to demand that the 47 million offer by Vodacom is not fair and is not equitable. Makate said he's resilient and said he's confident that finally or one day this matter will end in his favor. That is it from my side, Mpokoka from Sunday World Newspaper. Follow us on our social media handles on Facebook, on Twitter, Instagram, TikTok. Follow us on our YouTube channel as well, Sunday World.